The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning. All 7 justices will be participating this morning, 2 remotely, Chief Justice Christensen and Justice Appel. And as you know, it's being live streamed as normal in the Drake 1L class assigned to listen in. So we have 1 case to be submitted this morning, John Lewis Arthur Anderson versus State of Iowa. Let's begin with a sound check. Mr. Jackson, we test your mic.
Good morning.
Colleagues, can you hear that?
Yes, I can hear. Thank you.
Mr. Sloven?
Good morning.
Again, Chief and Justice
Yes.
Appel, you both hear
I can
that?
hear. Thank you.
Very good. Thank you.
All right. Mr. Jackson, you may begin.
May it please the court, counsel, Your Honors. Your Honors, the John Lewis Anderson was convicted for robbery first and burglary in Polk County Court, FECR 233112. He was tried April 6th, 2010, and convicted and was sentenced April 27th, 2010. He was sentenced to a 25-year prison sentence on robbery first and burglary first. At the trial of that matter, the state offered testimony of DeJaren Counsel, who testified that Mr. Anderson was involved in the robbery planning. Mr. Counsel filed direct appeal of this matter. That appeal from the conviction was denied. The procedendo in that matter was issued August 18th, 2011. He thereafter filed post-conviction relief proceedings urging that constitutional concerns dictated that he ought to be granted a new trial. Those were denied. He has filed the most recent post-conviction relief action June 14th, 2018, asserting newly discovered evidence and several claims, along with newly discovered evidence, as well as a freestanding actual innocence claim under the Iowa Constitution, dictates that he be granted a new trial. That post-conviction relief proceeding, filed June 14, 2018, as a ground asserted the newly discovered evidence of DeJaren Counsel's letters mailed February 10th, 2010 to a third party, Rebecca Gladney, a defense witness, which indicated that if Mr. Counsel was called as a witness, he would testify that Mr. Anderson was not involved. And secondly, a letter dated February 14th, 2017, which was also from Mr. Counsel, which indicated that Mr. Counsel had lied in his testimony, that he felt forced to lie, and that Mr. Anderson was not involved in the robbery.
Counsel, what's your best case for allowing delayed appeal and post-conviction relief proceedings? What's the best argument for that?
So under the case law, we have this court and the Court of Appeals and the appellate courts have urged that belated appeals were appropriate in certain civil actions, termination of parental rights, for example, where in interest of KO that was decided in September of 2020, which indicated that a father who directed his attorney to file an appeal, that appeal was filed late. This court found that, or the Court of Appeals found that in the interest of justice, that late appeal ought to be granted because of the constitutional rights that an interest that are within a termination of parental rights case. The courts have certainly found that in the mental health commitment realm, that those that were committed have an interest, a liberty interest in not being hospitalized longer than is required.
So how does that interest extend here if the defendant's had a first appeal as a matter of right and has had an opportunity for post-conviction review? What is the constitutional necessity of allowing a delayed appeal from a denial of a post-conviction relief, which is already a collateral proceeding with respect to the judgment?
Mr. Anderson has urged that there is newly discovered evidence which would warrant a new trial. And if that's the case, he should not be imprisoned at this time.
Counsel, his lawyer said that he didn't timely file the appeal notice because of a miscalculation. But this appeal wasn't actually filed until 6 months later. It strikes me as odd that you would miscalculate it by 6 months. What are we to make of that statement?
Well, Mr. Anderson would urge that if you are provided with counsel, he ought to be able to rely upon that counsel doing a job, and that job be done to constitutional standards. So if he makes a good faith showing that he directed his attorney to appeal, which this attorney has indicated Mr. Anderson did so on May 31st, then a represented individual ought to be entitled to that attorney doing the job, and the delay period should not be attributed to Mr. Anderson asking him to essentially represent himself in filing a notice of appeal when he's been provided counsel to do so.
Well, let me ask a question there. You wouldn't suggest, or would you, that if the notice of appeal was filed 2 years after the fact, or 3 years, I mean, there's a period of time where even your client probably runs out of time to appeal. You've established that the lawyer made a miscalculation, but what you haven't established is whether your client knew for 5 months or 3 months or how many months that he wasn't filing the appeal. There's a kind of a second prong here that you haven't addressed.
Well, Mr. Anderson has counsel that he can presume is doing his job and filing that notice of appeal. And in the appellate realm, cases move deliberately. They don't move necessarily with a lot of speed because we want to make sure that the issues are appropriately considered. So if there is a notice of appeal that's filed, we would then thereafter have a briefing deadline. And
but let me put this hypothetical to you. Supposing your client found out on June 1, that the lawyer miscalculated and wasn't going to file an appeal, kind of said, I'm sorry, I missed the deadline, I'm not going to file. Suppose that happened, and then he waited 3 months, 4 months to file an appeal. Would that be subject to a delayed appeal when he himself delayed for 3-4 months?
Well, we would urge that given the situation of an incarcerated inmate, that when an individual doesn't have the same, necessarily the same abilities to communicate with the outside world and sits behind bars trying to determine maybe what's happening, that if that should be taken into consideration on what would be a reasonable time period.
Counsel, is there anything in this record that tells us when your client learned that his appeal hadn't been filed, so we can figure out whether he did act in making a good faith effort to getting this appeal filed as quickly as he could?
The record indicates in the motion that he advised his attorney several times to appeal. It doesn't indicate dates.
Mr. Jackson, is it clear that Mr. Anderson communicated within the 30-day period that he wanted to appeal? It seems to me it's clear that the attorney initiated a communication with Mr. Anderson, but did Mr. Anderson communicate back?
It is clear in the communication from the attorney, the statement to the court, that directive to appeal was timely. May 16th was the date. May 16th was the date of the court's decision. May 31st was the date that my client, Mr. Anderson, directed his attorney to appeal the adverse ruling, certainly within the 30
Mr.
days.
Jackson, I'm over on Zoom here. I'd like to ask you, I think it seems like there's a couple different delays we're talking about. We've spent quite a bit of time talking about this 6-month delay on the notice of appeal for the PCR3. But even getting to PCR3, there was 16 months after Procedendo had issued from PCR2. So I'm just wondering about the Kelly case that talks about being promptly filed. Can you talk about that delay as well?
Well, the newly discovered evidence would get around the 822.3 bar is what we would urge this court.
Well, that's what you're urging us to do. But if there is not, if the court were to determine the evidence isn't newly discovered, I'm just wondering, how do we get beyond that? Are there any other issues, or is it just the newly discovered?
First and foremost, the direct appeal Procedendo issued August 18th of 2011. So the 3-year time period would have run roughly August 17th, 2014. The recantation letter from Mr. Counsel was in February of 2017, so certainly after that 3-year period of time. The standard.
Yes, but what about the first letter? The first letter is dated before trial and is addressed to a specific individual who testified on behalf of your client. Can we assume that the first letter was available and not newly discovered evidence? I mean, what evidence is there that in the record that you used diligence and didn't discover the pretrial letter?
So the letters could be considered two different types of evidence. The first February 2010 letter from Rebecca Gladney could be considered impeachment evidence, which this court has found to be the type of material evidence which, if newly discovered, would provide a ground of fact. The second letter would be recantation evidence. So the first letter, if available at trial, he could have been used to cross-examine Mr. Counsel and say, well, you're testifying this way now, but you told officers, you told individuals something else according to this letter. The second is, I lied when I testified. So two different kinds of information. So even if that first letter was available and discovered within the 3-year time period prior to 2014, that second letter certainly was not. And it certainly was inappropriate to find as a matter of law that second letter dated February of 2017 was found, could have been discovered before 2014 because it's dated after. So certainly a genuine issue of material fact had been raised as to whether or not this information was new information and whether or not it had a nexus to the criminal conviction. The courts have held that, this court has held that impeachment evidence is the type of evidence that could be the type of evidence which would support a material claim for ground of fact exception to the 3-year bar. This court has also held that recantation evidence is the type that would be the type that has the potential to be material to a ground of fact exception to the statute of limitations.
Mr. Jackson, I want to ask you something else about, you know the record better than I do, but didn't your client testify about that in his first PCR, about that letter?
Looking at the prior PCR in the information that was cited, I believe, in the state brief, it did not appear that he indicated anything regarding a letter. It was a discussion about Mr. Counsel being taken off the stand and then coming back and testifying differently.
Let me connect the dots here where my first question and this one are tied together. I'm just wondering on those letters, those two letters, whether it be the first one that predated the trial or the second one, I thought that was referred to and testified to about in PCR 1, which is why I was getting to my earlier question about the delay of quite 16 months, I think, between PCR 2 and 3, and actually 17 months between PCR 1 and 2. That's where I was going. So wasn't the issue of the letter talked about in PCR, an earlier PCR?
It appeared to me that the issue was not discussed.
Okay. Thank you.
We urge that the district court erred in finding summary judgment. Thank you.
Mr. Sloven?
Thank you, Your Honor, and may it please the court. Good morning, Louis Sloven on behalf of the state. So on the merits, or not on the merits, but on the 822.3 time bar issue, I think that this is a relatively easy case. Chief Justice Christensen, to answer your questions, the 2017 letter obviously did not exist at the time of the first PCR, but his first PCR testimony described almost exactly the contents of the 2017 letter, showing that the 2017 letter, while it may be written on a new piece of paper, does not contain a new ground of fact upon which a PCR claim can be raised. It's all facts that he knew, so we think that this is very clearly time barred. I want to talk about the delayed appeal issue. In my view, this is all framed by Swanson. Swanson says that, yes, we do allow delayed appeals in some rare circumstances, in situations where there would be a serious threat of a due process or equal protection violation if we didn't. But this has never been considered a discretionary action based on mere excusable neglect. Instead, this requires us to find that a serious constitutional violation, either due process or equal protection, would result if we denied a delayed appeal.
And how do last week's cases kind of square with that theory?
So my view is that INRI A.B. looks at Swanson and then looks at the due process interests that are implicated in TPR cases and says, this is a situation where there's no further recourse to a PCR, there's no collateral review of what happens or review of the effectiveness of counsel's assistance in a TPR case. And so there is that danger of a due process deprivation if a person who makes a good faith effort to appeal and acts diligently doesn't receive any review of those proceedings because of the ineffectiveness or failure of counsel.
Maybe this case isn't the right case, but let's assume you had a case with a very clear-cut, meritorious argument for the defendant.
Which I think is always correct to do because that's always what a statute of limitations or a timeliness limitation like this is.
Okay, so maybe this is kind of, you're anticipating the question then. Why are you saying or conceding that delayed appeal should be allowed depending on the strength of the underlying claim?
No. What I'm saying is that it must apply regardless of the strength of the underlying claim. Now, I think that there is a fact-specific determination. That's something that Swanson and all the preceding cases had always said. But the fact-specific inquiry is about the reason why someone is before the court asking for a delayed appeal. Specifically, and INRI A.B. says this, did they clearly intend to appeal? The prior cases had kind of required that this be communicated to a court during the appeal period, but in INRI A.B. it was just communicated, or I think it was the companion case where it was just communicated to counsel. 2, was the failure to timely appeal outside of the parties' control, within counsel's control, but not the parties? And 3, was the resulting delay no more than negligible? So that's the fact-specific inquiry. Now, I think that whenever you talk about a statute of limitations or a timeliness requirement for the appellate court to have jurisdiction to review the case, you have to envision it applying to all cases regardless of the underlying merits of the claim. That what a timeliness requirement or a statute of limitations does is it says, after a certain point, the interest in finality and repose takes precedence, and we stop.
Counsel, is 6 months a negligible delay?
I don't think that it is, Your Honor, and I think that to answer some of the previous questions about the state of the record, I think you're right, Justice Mansfield, to point out that the statement that we have from the attorney says when he initiated the communication, but it doesn't specifically say when the applicant said that he wanted to appeal. Now,
See, that's my concern, is it could have been he wrote a letter to the client, and we don't know when the client communicated back. That's the normal communication, typically with someone who's incarcerated, is by mail rather than by telephone.
and I agree with that, and I think that Justice Waterman, to point out the 6-month delay, well, first off, I think there's no way to characterize that as negligible, but I also think that if you look at the motion for delayed appeal, it says that they communicated on numerous occasions. Now, where the motion for belated appeal and the statement from the attorney conflict, you could read in a conflict because the statement implies that there was only one communication. I don't really know how to resolve that. It's been suggested to me that what this court used to do was require the district court to resolve those factual disputes about what actually happened. That would be Gleason versus Brewer. We didn't make a motion for limited remand. I'm not sure. I don't know if that's the procedure that this court would want to return to.
Mr. Sloven, let me ask you about PCR, where so far we have not allowed delayed appeals, and on the other hand, direct criminal appeals and TPR, where we have allowed direct appeals. Now, one could argue that with the criminal appeal and the TPR, there's an important interest in finality, and that might counsel against having delayed appeals because those are matters that need to become final. For example, let's say the defendant is on bail, out on bail pending appeal, or let's say a situation where in a TPR where the new placement for the child cannot go into effect until the termination becomes final. On the other hand, with the PCR, you don't have that countervailing consideration. There's no concern about getting to finality. In this case, the defendant is incarcerated. So what's wrong with letting him have a delayed appeal? Why is it of concern to the state? Why does it trouble the state so much?
I think that I would agree with what you're saying about direct appeals and TPR. I think that those interests are heightened on the parts of all parties. That there's there's an arguable due process interest in the initial review of the underlying proceeding that results in the deprivation of the liberty interest. Now, for PCR, like you're saying, I would contend that there is still a very strong finality interest. We've got victims who don't want to be called back to testify years after the fact. I mean, the case I like to point to is Herbeck, where 15 years after the dismissal on jurisdictional, or the dismissal of the PCR court said, well, we don't have jurisdiction to consider your application to reinstate. Now, I think that Herbeck is problematic.
That concern really doesn't hold, sorry, it's Justice McDonald. That concern really doesn't hold with respect to delayed appeal because the post-conviction trial's already occurred. So the witnesses have already been called. The only issue here is whether or not the state has some sort of interest in not allowing appellate review of an already completed post-conviction proceeding, right?
Well, Your Honor, I think it's the interest that we always have in trying to push these cases towards finality in order to get some sort of closure for victims, repose, avoid needless expenditure of resources. And I would add that this isn't really just a straight balancing of interests, This is about a jurisdictional defect. This is about, does this case present the kind of threatened due process violation that would override normal limitations on our jurisdiction and say, well, we don't have a rule authorizing legislation under Root v. Tony asserting jurisdiction is arguably unconstitutional under Article 5, Section 4, but we must to avoid an unconstitutionality if we don't.
Well,
and that's
but
what you're looking to find here.
Yeah, he has a right to effective assistance to counsel in the PCR proceeding. I mean, that's been established. Go back, Patchett, Dunbar, Sims, and Lato, for example, where the post-conviction lawyer, failed to correct a 1944. You're familiar with the case, I know you are. So it seems to me that there is a right to effective assistance to counsel in PCR. This lawyer apparently provided ineffective assistance. I mean, if you don't, let me put it to you this way: if your client timely instructs that you file an appeal and the lawyer doesn't do it, that is ineffective assistance, it seems to me. Then the question is, well, what about this delay? If the facts turned out that he, and this is a hypothetical, but if the facts turned out that he called his lawyer or talked to his lawyer and his lawyer says, I'll fix it, I'll file a delayed appeal. Okay. And he called him back again and talked to him again. I'm going to file a delayed appeal. Okay. If those kind of representations were made, kind of stringing him along, that might be one thing. On the other hand, if he found out kind of promptly that his lawyer wasn't going to do anything, he sat on it for 5 months, 4 months, 3 months, even, seems to me, that might be another. Doesn't that mean this remand business might make some sense to figure out exactly who knew what, when, and how, and did Mr. Anderson just delay too long? I mean, if he knew and didn't file within 30 days of knowing that his lawyer wasn't going to appeal, that might be a problem for him, right? But why should we send it down to clear it up?
So on the minor premise of do we need to clear this up? I don't think so. I think that what we already have is clear enough that you know that you can't find excusable neglect isn't even the standard, but you can't even find that. You can even look back at Mr. Anderson's prior appeals. In 15-1809, that one was not timely served by notice of appeal in the district court either, and he was warned about that. And he knows about jurisdictional guidelines for appellate jurisdiction, the timeliness requirement being jurisdictional from when he asked for extra time on his further review application. But I think that the 6 months, there's just no way to find that fits in with INRI AB. Now, I am very excited in a future case, I think, to talk about the existence and the contours of whatever right to counsel exists on PCR. I think that the case that I want to draw your attention to is Coleman V Thompson. Now, I know Allison talks a lot about this case and Martinez. In Coleman, the Virginia Supreme Court dismissed a state habeas appeal, so initial collateral review, because the appellant, with counsel, missed the jurisdictional deadline for the appeal by a matter of days. And Virginia applied a similar rule like Swanson and found no cause for granting the delayed appeal. And the U.S. Supreme Court said, under AEDPA, we're going to apply a cause versus prejudice, or a cause plus prejudice standard. Otherwise, this has been procedurally defaulted. And constitutional ineffective assistance of counsel can qualify as cause for that purpose. But ineffective assistance of counsel where there's only a statutory entitlement cannot. And that, I think, and then Martinez specifically says it's not touching that holding. It distinguishes Coleman and says, look, that's about the appeal from the initial collateral review where the opportunity to raise the ineffective assistance of counsel claims.
That raises another point. I mean, in effect, what we're doing is precluding the federal habeas as well as the state habeas by what we do, because he has to exhaust, and he can't. He's going to end up being defaulted by our procedural rule and can't now pursue a federal habeas over the same claim either, right?
Well, I think it was already defaulted just because of the extended nature of the litigation. I mean, this is a third PCR, and that I think is ultimately what has to be kept in mind whenever you analyze whatever due process interest is being asserted here. That
You're right, he's too far away from the original date of conviction. But even so, I think that there's, we have to be concerned about the next case, don't we?
I think that's right. And so maybe the best way to resolve this case might be to say, whatever due process right might exist, and we can litigate that in a case that's closer. Certainly by the time you've already had the initial collateral review and the appeal from that, whatever due process right that may be burdened by the application of a timeliness requirement for appellate jurisdiction, that no longer exists in a way that you would find it could exist with TPR claims, direct appeal.
Mr. Sloven, I have a follow-up for you. Our earlier cases deciding kind of delayed appeal dealt with, I think, jurisdictional statutes, and now those are set by rule. And I guess my question for you is, do you think that our rules are truly jurisdictional in the sense that they deprive the court of authority or power? There's some indication in federal case law that that's no longer true, that the federal courts draw a distinction between jurisdictional statutes and kind of quasi-jurisdictional rules, which the court has the authority, obviously, to change, and then therefore, on a case-by-case basis, not follow. What is your take on that?
And I see my time's expired great, thank you. So I think that footnote 2 of INRI AB, I think, sets this out pretty clearly that, and it's discussed in Root v. Tony, that because of the legislative council's ability or participation in the process, that the rules effectively become statutory and are therefore imbued with the power to constrain and define appellate jurisdiction under Article 5, Section 4 of the Iowa Constitution. I also think that I think that that's sufficient to answer the question. And if there is a question about the constitutionality of that limitation, I don't think that this is a case that implicates that. And I don't think we would recognize a facial challenge like that. So certainly no due process problem here. And I think this court should reject the delayed appeal. Thank you.
Mr. Jackson, your rebuttal.
Thank you. Justice Mansfield, if you review Mr. Einwalter's statement to the court, the question of when Mr. Anderson notified his attorney to appeal, I think, is answered. The communication that Mr. Einwalter had was on May 31st, in which this attorney did inquire whether the applicant would wish to appeal. And then if you look at 4, the applicant indicated that he did want to appeal. And then you look at 5. The attorney subsequently miscalculated the filing deadline, which certainly indicates that Mr. Anderson demanded that his attorney timely appeal. Under 822, there is no requirement that you only get 1 or 2 bites at the apple. If there is newly discovered evidence, that newly discovered evidence may come at any given time, and it may come after you've had several bites at the apple. At the very least, this recantation letter dated February 2017 created a factual issue on whether or not there was a ground of fact to get around that statute of limitations, 3-year statute of limitations. Whether or not it's the first, second, or third, the constitutional interests, the rights, procedural and substantive of a convicted individual incarcerated in prison should be addressed. It should not be precluded simply because there's been prior attempts on other grounds that have not been successful. Newly discovered evidence is the ground that Mr. Anderson has urged. The standard was ground of fact. Did he establish a ground of fact that would be sufficient to get him past that statute of limitations, 3-year statute of limitations. That ground of fact need not be dispositive of the claim for a ground of, for newly discovered material evidence. That was not asserted by the state in their motion for summary judgment. This didn't reach the merits. Moon versus State, for example, they urged the they urged that the statute of limitations barred the matter, but also that the claim lost on the merits, and as the court has indicated, they reached the merits. This is a case where the merits weren't pled as a ground for motion for summary judgment. The sole ground that the district court applied was the statute of limitations, that these were time barred.
Mr. Jackson, I want to ask you a question. Mr. Sloven said that maybe not the letter itself, but the contents of the letter, the gist of those letters, were a part of the prior PCRs as far as the evidence presented or testimony. Do you agree with that?
Well, taking the matter in the light most favorable to Mr. Anderson here, as would be appropriate under the summary judgment standards, the evidence before the district court demonstrated that the letter was February of 2017.
Okay, the letter was, but the gist of the letter, what was talked about, the circumstances, was that at issue in one of the prior PCRs?
Well, I guess, Your Honor, what Mr. Anderson is indicating is the facts that were presented to the court created a genuine issue of material of fact. Maybe at a later date, with a full hearing, a factual record could be developed where under the newly discovered evidence standards, it could be determined whether it was actually newly discovered. But in this instance, there certainly was a genuine issue of material fact as to whether or not that information was known. And in Mr. Anderson's claim, he has asserted that it was newly discovered. So newly discovered plus a letter dated is enough to generate an issue of material fact as to whether or not it was a ground of fact sufficient under this case.
Counsel, if we find this appeal is untimely and does not satisfy the requirements for delayed appeal, does Mr. Anderson get an additional PCR based on ineffective assistance and then get a day in court, perhaps, on his actual innocence claim?
Well, certainly the Blanchard v. Brewer case has indicated that a failure of appointed counsel to commence the simple steps for an appeal is a blatant denial of due process. So I see my time has expired. So I would indicate that yes,
you can complete your answer and sum up.
Yes, Your Honor, potentially.
All right.
So we would urge that the district court erred in finding no issue of material fact on the ground of fact, exception to the 822.3 statute of limitations. We urge this court to grant a delayed appeal in this matter and find that the district court erred in granting the state's motion for summary judgment. Thank you.
Thank you, counsel. Anderson v. State is now submitted. Bailiff, you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.